With it on behalf of Ms. Crittenden. Ms. Crittenden, can you please state your name for the record?
Savannah Crittenden.
You're requesting an adjournment. You were just recently appointed.
And right away, this hearing starts with a classic courtroom tension point. A newly appointed defense attorney stepping into a case without discovery, but still trying to address bond. That matters because discovery is the evidence package, the reports, allegations, witness statements, and details the defense needs before making a fully informed argument. But bond? Bond affects whether the defendant sits in jail or gets released while the case moves forward. So the defense is walking a tightrope here, asking for more time because they just got the case, while also trying to convince Judge Simpson that release is still reasonable. And that is where things get interesting. Because when a bond request comes before the court, the judge is not just asking, can this person come back to court? He is also asking, is there a safety concern? Watch closely, because the prosecution is about to bring in allegations that completely change the tone of this request.
Yes, Your Honor. I was just appointed yesterday, so I don't have discovery yet on this matter. However, when appropriate, I would like to address bond.
During the matter, July 31st, 2025, 9 a.m. Yes, that's the bond briefing.
Your Honor, it's my understanding that these alleged incidents allegedly took place at an extended stay hotel while Ms. Crittenden's apartment complex was under construction. She has before staying in that extended stay hotel, had not known, and I would argue still does not know, the alleged complaining witness in this case, has no reason to have contact with them. I'm still trying to determine whether the construction at her apartment complex is complete. But Your Honor, I think that given the circumstances, I'd be asking for a release on a PR bond with a GPS tether with potentially a no-go to that extended stay hotel.
Response.
Your Honor, we would ask that the bond continue as set until the next probable cause conference date. The defendant was under investigation for criminal sexual conduct with a minor. That investigation was furthered for other information to be obtained. Ms. Crittenden was advised not to have any contact with the minor or his father, although there was no bond condition. She immediately went back to the hotel, had contact with the minor and his father. The police had to be called. The police came out, instructed her not to have contact with the minor and his father. The police left the hotel and were dispatched back again. She was in contact with the minor and the father and making hence the stalking charges. So we would ask that the bond continue.
That prosecution response is a major problem for the defense. The argument is not simply, we oppose release. The prosecution is saying the defendant was told not to contact the minor or the father, then allegedly returned to the hotel, had contact anyway. Police were called, officers warned her again, left, and then had to come back a second time. That is exactly the kind of pattern judges look at when deciding whether bond conditions are enough. A PR bond sounds light because it means personal recognizance, release without posting money, based on the promise to return and follow conditions. But if the allegation is repeated contact after warnings, Judge Simpson has to ask whether more conditions would actually work. And here is the engagement question. If someone is allegedly warned once, police respond, then police have to return again. Would you trust a GPS tether and no-go order to solve the problem, or would you keep the bond exactly where it is?
And Your Honor, if I may,
Yes.
Again, I just want to make sure it's clear. The CSC allegations, it's the same complaining witness as in the stalking charge. And again,
I'm just going to get that.
So I just want to make sure that was clear, Your Honor. And again, I don't believe she has any reason to have contact with them. And I think a GPS tether with a no-go.
But as I understand, she was told, she was under investigation for a CSC, told not to have any contact with this specific individual as well as his father.
And she denies those allegations, Your Honor.
Understood, but the allegation is that then the police were called back twice after she was informed of that. and that there were threats, which, as Ms. Reiser's indicating, have led to the stalking charge. I'm actually, given ththose allegations, surprised that her bond is set so low. Motion for bond reduction is denied.
Thank you, Your Honor. One more thing, Your Honor. I apologize. I was hopeful that Ms. Crittenden would be released and we could have an afternoon spot on the 31st. I do have a conflict in the morning.
You can talk about this. Well, it's going to be in the morning.
Right. No,
Put it on the 7th.
That's what I'm asking for, Your Honor.
All right. Probable cause conference, August 7th, 2025, 9 a.m. Bond will continue. Motion for bond reduction having been done.
Thank you, Your Honor.
What are we doing? Sir, Mr. Dick, he's still muted.
Yeah.
Why is he brought up?
Oh, there he is. Sir, can you state your name, please?
Ibrahim Jakaite.
Okay. What are we doing?
In the matters that I represent, Mr. Diakete on 1232 and 1233, we will be requesting a set for a preliminary exam. To my knowledge, all discovery is complete in both of those cases.
Same with 5153.
You want an exam set?
Yes, Your Honor.
Now the courtroom shifts into another case, and this is where these hearings can feel routine until bond comes up. A preliminary examination is being set, discovery appears complete, and everyone sounds like they are moving through scheduling. But do not let the calendar language fool you. Preliminary exams matter because they decide whether enough evidence exists to move the case forward. And when defense counsel says they want an exam set, that means they are not resolving the case today. They are pushing it into the next legal stage. Judge Simpson is managing the docket, checking witness availability, and keeping the process moving. But notice the pattern. Once the exam date is handled, bond becomes the next battlefield. That is common in these hearings. First, the court locks in procedure. Then the defense tries to reopen liberty conditions. And as soon as bond is mentioned, the tone can go from administrative to explosive in seconds.
I did meet with him last night.
So keep an eye on.
People have their witnesses available the 29th.
We'll do our best, Your Honor.
Preliminary examination will be set in person July 29th, 2025, 9 a.m. before Judge
Judge Washington.
Washington.
And Your Honor, when appropriate, my client would like me to address bond.
Go ahead.
Yes, Your Honor. Mr. Diakate would like me to request a release on tether. He does not reside at the same location as the complaining witness in the 1232 case. Prior to incarceration, he began working full-time as a caregiver. He'd like to be able to return to that work. He has no reason to be in contact with the alleged complaining witness in this case. No children in common, no residents in common. He does have his own transportation. He'll be able to return to court. He does have ties to the state of Michigan as he has family who resides within the state in different cities. So he'll be requesting a tether with a release on tether, personal reconnaissance bond for release on tether in his cases.
Your Honor, just two things on my case. I'm trying to figure out what the bond is. Does your record show what the bond is on the 23 case?
The 23 case bond is 1,010%.
All right, thank you, Judge. I would just echo that, Judge. Request for bond, and again, this is a 23 case that happened in the jail.
Response.
Your Honor, I would object to any modification of bond. This defendant is looking at 3 cases here, and I'll go through each one by one. In his R&O case, he is an officer tried to stop the fight and told the officer that he was going to kill him when he got out of jail. At his next case, he was throwing rocks at someone's windows. Officers arrived, saw a motorcycle leaving, confirmed it was the defendant, and a pursuit began where he reached speeds of over 100 miles per hour in a 45-mile-per-hour posted zone. He was caught after the motorcycle had stalled, and the motorcycle turned out to be stolen.
This is where the bond argument gets buried under the weight of the allegations. The defense was asking for tether, emphasizing work, transportation, family ties, and no need for contact with the complaining witness. Those are normal bond reduction points. But the prosecution responds with a stack of alleged conduct across multiple cases: threats in jail, rocks being thrown, a motorcycle chase at over 100 miles per hour in a 45 zone, and then a stolen motorcycle allegation. That is not a minor bond concern, that is a public safety argument. Judge Simpson is hearing not one isolated incident, but a pattern the prosecution says shows danger, escalation, and disregard for law enforcement. Here is the key legal clarity. Bond is not punishment at this stage, it is risk management. The judge is deciding whether conditions can reasonably protect the public and ensure court appearances. And with allegations like this, tether starts sounding much less persuasive.
And then in his third case, him and the victim who were working together, had a dating relationship. An employee at that restaurant called 911 to report that the victim had been dragged from the women's restroom, kicking and screaming, to a car. And the colleagues at work had saw visible scratches on her face. And after being put in the car, the defendant then drove away and the victim jumped from the car and officers found her in the middle of the roadway. I also wanted to report that he has a previous DD conviction from 2023, and he currently has a hold from Delta County with bond denied. So I would be asking that bond remain as set in this case, Your Honor.
Anything else?
No, yeah.
All right.
Nothing from me. Nothing
Given
from me.
all of those circumstances, motion for bond reduction is denied. Bond will continue in all three matters.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case.
And good afternoon, Laura Yagi, Assistant Public Defender, with on behalf of Ms. Hill. Your Honor, I do have a green sheet. I apologize. I am seeking an adjournment for further discussions regarding the case.
In objection, I did want to address
Probable cause conference, August 7, 2025, 9 a.m. Yes, Esteban.
Simply wanted to request, there is no testing order whatsoever on this file. I provided the court, you may have the hard copy of Ms. Hill's. I think it started with trouble and she may now be on scram or vice versa in her circuit court case. I just wanted to ask that we have an order here to accompany that so that we get those results, because currently they're only being sent to 27.
Oh, you guys don't get them. I get them because of our game, but I got you. You're on a scram now. Right. When did you go on a scram?
Now we move into a very different kind of bond issue, scram monitoring. A scram tether is commonly used to monitor alcohol consumption, and here the discussion is not just about whether the defendant is being monitored, but whether the correct court and parties are receiving the testing information. That may sound technical, but it matters. If a person is ordered to comply with alcohol testing and the results are not going to the right place, enforcement becomes messy. Judge Simpson quickly recognizes the practical issue. There is already a scram device, so the court does not need to physically add another one. It just needs an order tied to this case so the monitoring's results are properly connected. And then there is that courtroom humor about running out of space, funny, but also revealing. These courts deal with overlapping cases, overlapping conditions, and defendants already wearing multiple layers of supervision. So the comedy lands, but the legal purpose is serious.
They put it on me before I got out of jail, July 8th or 9th.
All right. What I will do is I'll continue the defendant's bond, and we'll order a scram tether on this case. We don't have to put another one on her.
Thank God, we're out of space.
What do you say?
We're out of space.
We got two left, so we can put one on each leg. We've done that before.
Your Honor, I'm so sorry. I'm just asking for civil standby. I think it was an oversight at arraignment, but we just need a civil standby for her to get her belongings.
To do what?
For her to get her belongings from her residence. She's been evicted, but it is the location that she's not allowed to go back to. But she was told that she could get her belongings with a civil standby. And for some reason,
I don't need to order a civil standby. You called me.
They wouldn't come out when I tried to do that. I said I had to be ordered by a judge. I'm not allowed on the property.
So I don't know if
Sheriff's Department told you that?
Yes.
If I scream loud enough, is that an order? Really? I've never. Ms. Yagi, craft an order.
Okay. That's
That's not how that works.
I was going to say, I'm happy to just send them JIS if the court just indicates like, okay for
Do an
civil.
order. They want an order?
Understood.
Do an order.
Got it.
People out of room, I'll put a big signature on it.
Thank you, Your Honor.
All right, thank you.
Roba Handon. I am here with and on behalf of Justin Hodge. Can you please say your name for the record?
Justin Paul Hodge.
Thank you.
Your Honor, we would like to set preliminary examination at this time, to
All right. Is all discovery complete?
the best of my knowledge.
All right. People have their witnesses available the 29th.
Try our best.
Preliminary examination in person, July 29th, 2025, 9 a.m. before Judge Barr.
And then, when appropriate, we would like to address bond as well.
Of course you will. Go ahead.
Your Honor, my client is asking for contact with his two children to be reinstated. He advises that he would not need to be in contact with the claiming witness in order to do so.
Response.
Your Honor, we would object to any modification of bond. The defendant was on probation when this case occurred for another domestic violence case in Wayne County. He's currently being held out of reign for that. He currently has a hold out of reign for that DV with bond being set at $1,570. And this current case involves the defendant having an argument with his girlfriend, taking her phone and smashing it, and his admitted to throwing the phone. So at this point, we believe bond is set as appropriate.
Were the children there at the time?
They were.
They were present at the time of
The 2-year-old was present.
the 2-year-old. So one of the children was there. Any other?
No, Your Honor.
All right. Motion for bond modification is denied at this time. Bond will continue with the conditions. Thank you.
Final stretch, and this last case brings the pattern full circle. Scheduling first, bond second, and then Judge Simpson weighing the request against the prosecution's concerns. The defense wants contact with the defendant's two children reinstated, arguing that contact with the complaining witness would not be necessary. But the prosecution objects, pointing to a prior domestic violence probation issue, a hold from another county, and allegations in the current case involving an argument, a smashed phone, and children being present. Judge Simpson's ruling is clear. The motion for bond modification is denied, and the existing bond conditions continue. The takeaway from this entire hearing is simple. Bond requests live or die on risk. Work history, family ties, and proposed conditions matter, but repeated alleged contact, public safety concerns, active holds, prior domestic violence history, or children being present can override those arguments fast. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.